Louisiana or something.
not drive. I am also putting on this affidavit that you're not going to drive. Do you understand?
Yes, sir.
You're looking around, you're just heed this warning, Mr. Bledsoe. Do you understand?
Yes, sir. Yes, sir. I totally understand. I only have one off day. I just sleep all day.
Did I hear him say that he had an objection?
No, Judge,
No, most
He was,
definitely not.
he was
No.
just asking a question.
Okay,
No
just
objections.
don't use. Stay out of trouble. You're in enough hot water as it is. You know, the thing is, Mr. Bledsoe, is that a lot of people make very, very poor choices when they're out there in life. And sometimes that choice makes it to where you will live the next 40 years in a 6x9 box. And I'm going to tell you now, I've read have you been to prison before?
Nope.
I've read, I want you to hear me. I've read stuff about what happens in prisons, and it had me in tears. It was as bad as could possibly, if you think of your worst nightmare, it's worse in our Texas prisons. They don't give a rat's behind about you, and you will be passed around like a proverbial doll. It's awful. Believe me, it's not worth it. Don't have a gun.
Yes, sir.
All right?
Thank you, Judge.
All right.
Judge, did you have the no contact and referring from as well?
Yeah.
Spoke with pretrial judge. I spoke with the coordinator. Per pretrial, he's tested positive presumptively, because they have to send it to a lab for confirmatory, for alcohol and THC. I think they described his behavior as
Threatening.
well, I didn't get threatening, but
I got threatening.
Okay.
And I'm going to tell you now, I'm not going to have you, and I'm not going to stand for your threatening anyone in this court at any time. That is, every part of this is an extension of us. I don't care where you're going. I don't care what building you're in, whether you're in pretrial services, whether you're taking a drug test. It's unacceptable, and I'm revoking your bond, and you now goes with you.
if I can, Judge, I don't believe there has been actually any evidence presented to warrant a
Hold
bond
on, Stephen.
revocation.
She told me yesterday that there had been multiple threats.
So, all right, to circle back, there's a couple things. In speaking with pretrial, I have not received any information about threats. I've received information about cursing and rude behavior.
Yes, Judge.
Don't
There was
speak.
no like threat of like harm or anything like that. It was just more so attitude. He was making people at our office a little bit uncomfortable just with his demeanor and the things that he was saying, but none of it, to my knowledge, has been anything, putting anyone in danger, threatening danger, anything of that sort.
This is
You
where I want,
have an open criminal case. You're to be humble and contrite. And when you're not, and when you're threatening, abusive, harassing, I'm going to take care of you and I will light you up like a damn Christmas tree. Do you understand? It is unacceptable, the behavior that you have displayed here with myself, with pretrial, with the people down over there. And if you don't straighten up and fly right, I'm going to be all over you. Do you understand? One false move again. This is not supposed to be a happy time for you. And I don't know what I need to do to get your attention. But next time, I will classify you as a danger, revoke your bond, and make it so high you will have teeth falling out. Do you understand? Take a seat.
thank you, Judge. Back to your point. You have a preference on the reset date, Judge? He's got-
So tell me what he tested positive for.
It was THC and alcohol, Judge.
Okay,
This is where I'll add that the court added bond conditions yesterday, so he had the
I
magistrate.
understand.
Okay.
He did have
So-
some these magistrate orders in October that I did see that he was instructed over. It didn't have no alcohol, but it did have liquor.
October what?
October
14th, 15th.
Give me the last name again.
Bledsoe, BLED.
Oh, no, he's still smoking weed then. I mean, if they told him not to use any kind of illegal drugs and he tested positive right now, give me the date, please. Come up, Mr. Bledsoe. You're not off the hook yet.
This is where I will repeat my assertion that since he's out on bond, he's entitled to a hearing where the rules of evidence would apply.
What we're doing right now.
Well, then I'm going to object to hearsay to anything and everything being heard by the court.
What day was the magistrate condition for no using, please? October 20th.
I'll give my spiel about THC seltzers that I could buy at Specs that have no alcohol but have THC in them.
You are not to use alcohol. You are not to use illegal drugs. I'm going to give you the benefit of the doubt, and I'm going to test you again in 2 weeks from today. If you test positive for THC again, and I don't care what it is, I don't care if it's a gummy, I don't care if it's a joint, I don't care if it's Delta 8, if it's Delta 9, if it's Delta 352, whatever it may be, you will stay with me. Do you understand?
Yes, sir.
Get whatever records you need. But if you test positive for THC again,
Yes,
you're
sir.
on notice now. You will stay with me.
Yes, sir.
Okay.
Thank you, Judge. Have a seat back.
What, hey, Vic, what page? 17?
Devin, last name Davis.
Good morning, Mr. Davis. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
The complaining witness and the defendant are married. Officers were dispatched to a residence in Harris County, Texas. They met with the complaining witness, who stated that she had called the defendant and noticed that he was intoxicated. Complaining witness then drove to the defendant's location to take his keys to make sure that he would not drive.
Smart. Wonderful.
The defendant refused to give her the keys. The keys ended up on the ground. The complaining witness went to pick the keys up, and the defendant started grabbing her, pushing her, and hugging her as they both fell onto the ground. Complaining witness said that she fell onto the ground and she felt pain and discomfort, and the defendant was on top of her. The officer noticed the defendant was much larger than the complaining witness, leading him to believe that the defendant falling on top of her would cause pain as well.
So did he intentionally assault? Was it an accident? I don't, read it again. You said he fell on top of her. Did you, isn't that what you said?
Yes, Judge. He hugged her and then they both fell to the ground. And then he had fallen on top of her when they fell to the ground.
This is a specific intent crime.
I don't think we have an offense report, Judge.
Well, nevertheless, this is what we do now. This is the probable cause hearing. You got to have it now.
This is a DVD case, Judge. I don't think that the complaining witness has been ripped yet.
Doesn't matter. I mean, we got what we got here, and I don't see intent. You know, in life, Mr. Davis, it's Davis, right? There are people who drink, they become very happy. You know, they're great to hang out with. They crack jokes. They're just the life of the party. And then there are those people, when they drink, they become the devil incarnate. They get horns. They just become terrible. If this strikes a familiar chord, don't drink. You know, it sounds like someone's trying to do something very loving, you know, really. I'm going to find no probable cause now because I don't see intent, but just be careful. You know what I mean? Just, you got one life. Be happy and be nice. All right? Just take a seat for me, please.
All right,